Yes, Mr.
With the global canvas on election funding, party funding, campaign funding, is like a kaleidoscope. I mean, it presents very interesting items, experiments made, and just as a learned solicitor were talking about experimentation. And he has referred to one of the most oft-quoted judgments in US, the New York Ice Company versus Lehman. Experimentations in economics and related branches to stay experimentation. The court looked at it with a distaste. So we look at all these experiments and how they have either invited a wide range of concerns. So I would address your lordships on three or four important aspects of the constitutional issues raised in this case. Before I do that, a very broad brush has been stated in this case. It is said that the scheme violates Article 14, 19, 21 and also undermines the basic structure of the Constitution. I think we need to take stock of this kind of propositions very closely. Alongside it also said, well, here is a manifest arbitrary and therefore Article 14 is attracted. I suppose that we must pay very close attention to an argument because the Constitution bench, in terms of Article 145, looks at substantial issues of interpretation of provisions of the Constitution. Except when a reference is made on a difference between different benches. So the substantial questions of interpretation of the Constitution, there has to be something very precise, direct, and not too overbroad statements, which may resemble a political debate. I understand that a good part of the arguments made come closer to a political debate rather than precise statement of infringement of any particular constitutional right. Why I say that is placing reliance on two judgments of your lordships in the Association of Democratic Reforms and the PCL case that for the purpose of expressing your choice of a candidate, and you need to know the criminal antecedents of a candidate, a specific issue on hand, and a concrete right to be exercised. The choice of a candidate. So when you have a right to know under that, you are not asking the court to declare that in Article 19(1)(g), the citizen should have a general right to have a knowledge about everything and anything in relation to the affairs of the community. You have a task on hand, namely the choice of a candidate. So therefore, you need to know something about a candidate. Therefore, it follows that you must have information relevant for informing you as to how you will exercise your choice. Therefore, the information issue will always be related to an expression with reference to a particular issue on hand. If you may put it like this, information relevant for determination of an issue, can be a freedom of expression. And that if there is a denial of that acquaintance, then we say there is an interference with the freedom of expression. So somebody calls it mutilation of the thinking process if the information is not available. So we talk about an issue on hand, and a denial of acquaintance of information forbids your ability to formulate an opinion and to reach a choice. So this scheme on hand is not concerned with political contributions per se. That's why I think the court would not get into the larger questions of where should political contributions come from? With what interest do they come from? And to what extent interest can be regulated? All those issues, I think, are completely alien to the scope of the inquiry in this case. That's why even if lots are invited to say the level playing field, it's only marginally relevant where one is looking at the effect of the scheme. Otherwise, those concerns, as I said, are completely alien to the narrow issue which is presented for consideration before your lordships. Because it happens in the generality of debates on election funding or political funding that one common starting point is that electoral reform is a claim that current systems somehow adulterates the outcomes that a purer system would produce. So we are not entering into the debate at all. Whether do we have a purer system and an adulterating system, how do you weigh them? Several imponderables would come into this question, both political, social, and economic. Therefore, that question not being relevant for consideration by the court. I'm just reminding, I'll read a very interesting statement made, not directly connected to this, but when the court is being asked to get into an arena of concerns, thoughts, and matters, and the court is asked to say, look, step in and give something better. So that's these words by a famous economist, John Maynard Keynes, way back in 1933. I'll just give it to you, Lord, after I finish reading this. Because when the community or even an individual is confronted with difficult choices, the question is in place of what prevails now, and if an alternative was to come in, it is not very clear about that alternative. I am perplexed. So he makes this very interesting statement. The decadent international, we are talking about capitalist power. Of course, capitalist power. But the capital today remains the lifeline of the nation. So he says this, the decadent international but individualistic capitalism, in the hands of which we found ourselves after the First World War, is not a success. It is not intelligent, it is not beautiful, it is not just, it is not virtuous, and it doesn't deliver the goods. In short, we dislike it, and we are beginning to despise it. But when you wonder what to put in its place, you are extremely perplexed. So these are very important words when any alternative system is sought to put in place. These questions have to be asked. So when we talk of the scheme being put to test and, let's say, undermining a basic structure doctrine, as Mr. Prashant Bhushan has put in his written submission, I want to deal with some of the issues so that straying away from the question for consideration and to sometimes draw a very broad statement about basic structure can become problematic. It can become too doctrinaire also. So I suppose the court it need not be called upon to enter into those questions at all here. There is one very inviting thought process that comes to all of us is that we tend to say basic structure doctrine is undermined or is in a way in peril. We tend to lose track of the features of the Constitution which are consolidated in the basic structure. There could be an individual picture which can be undermined or in breach. So it is the architecture of the Constitution which is brought in and say basic structure undermined. We have to give very close attention to whether that can ever happen at all in the way it is stated. I wanted to share this broad statements and a few more propositions before I take your lordships to. Just digressing here for a minute. We talked yesterday about free and fair elections and the level playing field, even though I said they're not relevant at all. I asked myself a question: if the information which now becomes coded under the scheme, coded in more than one way, is to be disclosed, and all citizens have a right to access to this information. What is that end which I will put to use by way of accessing this information? General political debate, or determining which party will do better, or we will talk about the quid pro quo after the quid pro quo event has occurred. So therefore, I'm asking the question as to for what end and for what concrete purpose is access to information, the information, if disclosed, would become relevant. So now I try to broadly make two important distinctions. One, what are the scheme sought to achieve and what the scheme has not addressed, or what it has not done and what it has done. So then we have some element of clarity on testing the constitutionality of this scheme. Before I go into that, so we have three, let's say, assume that a 19(1)(a) right is available to all citizens and must be made available to all citizens in order that we participate on an informed basis in a healthy democracy. Too broadly stated though it may be, and we assume that it is probably so necessary. Though I say today there is no such statement of law available except those two judgments where the statement of law is for the purpose of knowing the antecedents of the candidate, a specific concrete purpose to be achieved. So unless we say this larger purpose will be the specific concrete purpose, we may have to look at it very differently. But before I dilate on that, I proceed